Hey everybody, how you doing? It's Alex Moyle here from Nurture It, and I'm super excited about today. As you know, on the Nurture It show, we try and find guests that help you not only build more as a recruiter, but help you build your business as well. And so today isn't really about sales pipeline, which, as you know, is what Nurture It's all about and what the topics that we most do are. Today we're talking about GDPR, and we've got a returning guest. We've got Francis Lewis from Osborne Clarke, and we're super excited to have Francis because since we did our last webinar, you know, GDPR is absolutely everywhere. It's totally crazy, and there's loads of silver bullets flying about, and everyone thinks they can fix it. But a few weeks ago, Francis and I were talking and going, you know what? Like, what I'm reading doesn't match with what we've been talking about. And so we decided to do another webinar on GDPR to help maybe address some of those misconceptions. And let me give you an example of a misconception. My friend Louise the other day got an email from one of the providers to the recruitment industry and sent her an email basically going, we can't send you an email unless you click we consent. And not only is that not right in GDPR, it's not even relevant to GDPR, but such is the noise and chaos around GDPR, people are starting to make bad decisions. And so what we're going to clear up for you over the next sort of 35, 40 minutes is some of those misconceptions that really you can start using to help you grow your business and handle GDPR in an effective way. So without further ado, hello, Francis, welcome back.
Hello.
Good to have you back. So we were talking a lot about misconceptions, and the misconceptions we're going through today, I think we've got down is about consent. And the how we use consent and the role of consent in GDPR. We're talking about LinkedIn and job boards and whether we can rely on what they're getting their customers to agree to for us and what we do as recruiters. We're going to talk about the CRM and some of the solutions that CRM providers have got getting. And lastly, we're going to talk about just do recruiters really have to change what they're doing. But since we last spoke, Francis, do you want to just give us a bit of an update as to what's been happening in GDPR world and some of the clarification that came out since Christmas?
Yes, okay. Well, just to put this in context, I advise a lot of UK recruitment businesses, and we've been working with a whole load of them over the last few months on their GDPR compliance projects. That ranges from fairly large international groups down to much smaller businesses as well. So we get to hear about a lot of the information that seems to be on the market at the moment in terms of offering as Alex says, a silver bullet GDPR compliance solution. And quite frankly, most of what I have seen and read is incorrect. So on several occasions, we have stepped in and helped recruitment businesses who have been just about to go down one compliance path. We've sort of backtracked with them and helped them realise that that's not the way to go, that if they did do it that way, they'd be creating massive problems for themselves. And we've given them an alternative which is far more realistic and doable, particularly in the timeframes that are available.
What are some of the consequences of acting upon misinformation or some of the misconceptions that are out there in the market?
I think the main one that keeps coming through, and to a certain degree, I think it could be because there's a lot of confusion around the terminology, is that you have to get consent in order to process a candidate's data, and that consent has to be for GDPR purposes. And the reason why that's not a good idea is because consent has to be very specific. It has to be in an intelligible, accessible form. It has to be distinguishable from everything else you send out. It can be withdrawn at any moment for any reason by the data subject. So the quality of consent that's needed under GDPR is very, very high.
Right.
And I think what a lot of people I've spoken to have not realised is that there are other lawful grounds for processing data that do not require consent.
Right.
And the Information Commissioner has confirmed, certainly since we did this session last time, that they do expect in most cases that businesses will be able to rely on other grounds, in particular the legitimate interest ground, in order to justify the processing that they're doing. So it is a question of only using consent where it's absolutely necessary. And an example of that would be where you've got special category data. For instance, if you have to have health data about a candidate, you would need to get specific consent for processing that piece of data. But for everything else you do with a candidate's data, you shouldn't need to rely on consent.
Right. Okay. So do you want to just recap briefly on what are I think there's 6 different sort of grounds for processing data. Is that right? Do you want to just recap on what those are? And then we can go back into the more detail around the legitimate business interest.
Okay. So other than consent, the main ones that recruiters would consider relying on would be that the processing is necessary for the performance of a contract to which the data subject is party, compliance with a legal obligation, and then it's necessary for the legitimate interests of the business. And it's the legitimate interests ground that is the most useful, because that for a recruiter would be you are using the data for your legitimate business interests, which are providing and offering recruitment services. Right. So it is a very useful ground, and certainly the guidance that came out just before Christmas provides a lot more detail about legitimate interest, and it is clear that is encouraging people to use that ground unless there's a specific reason not to.
Right. Okay. So if I just recap, so for instance, to fulfil a contract would be that I need to keep candidates' details on the system or have their bank details in order to pay their wages if they're a temp or contract candidate.
It does boil down to that. I mean, in most cases, staffing companies, unless they're paying PAYE temps, don't actually pay the data subject themselves. You know, you've got a chain of contracts in the supply. But provided you are, as a staffing company, an essential part in that supply chain, usually because you've got the contract with the client, then you could rely on that ground at the stage in the recruitment process where that contract comes into being.
Okay.
The difficulty recruiters have is that the early stage collection part of the process requires a different ground, because at that stage there is no contract.
So for instance, Claire's written a question here. So if she's using a job board to review CVs and she contacts a suitable candidate, if they said they're interested in the role and has spoken to them about the role, but she doesn't have email confirmation, can she still use legitimate business interest?
She can use it, but one of the key things you need to do in terms of making sure that you can rely on these grounds is to make sure that whoever you're dealing with is given notification of your fair processing information, it's called. So that's variously referred to as a privacy policy or a fair processing notice. They've got many different names, but it's basically the explanation you give to data subjects as to where you're going to collect the data from, what you're going to do with it, why, and on what lawful grounds. And as long as you send out that information at an early stage in your recruitment process, and you can do that via a link to your website, if that's where you've got your privacy policy, then you've put them on notice as to what you're going to be doing with their data.
So what you're saying is I find a candidate on the job board, I speak to them, and then when I put the phone down, I send them an email going, this is what we're doing, here's a link to our privacy policy, and effectively you've given the candidate notification of what I'm doing, and this is what you can do to undo what we're doing type thing. So you can opt out or etc.
That step is really important, and if you can get a direction towards your privacy policy at the earliest possible stage, you are providing a really good cornerstone for compliance with GDPR.
And so would that count then that if I've downloaded a CV, this is sort of, we're getting into number 2, but I'll stop on it now. If I download someone straight from a a job board and I haven't spoken to them, as soon as I download it, if I just send them an email going, hi, this is Alex, or this is this company, we've just got your CV from this job board, this is what we're doing with it, we'll be in touch. Would that still be is that still a useful cornerstone to have?
Yes, I mean, ideally you'd have a privacy policy. I mean, I think you wanted to touch on this, Alex, but regardless of the size of your organisation, I think a well put together privacy policy that ticks all the boxes for GDPR is going to be very, very important and useful. Okay. Because once you've got it, you just direct people to it. You send it in emails, you do automated responses. It doesn't matter how you communicate it, as long as they've received it. You don't have to show they've read it, but you do have to be able to show that they've received it.
So step one is, no matter what you're doing, no matter what your size, you need a privacy policy, and you need to make sure you're directing people to that as rapidly as possible.
I'd strongly advise that. And that seems to be what a lot of this boils down to. I mean, there's all sorts of extra bits and bobs all over the place and compliance that you can look into, but the privacy policy is an important foundation from which everything else seems to get built on.
And in the previous webinar, we spoke about the importance of process, understanding where your data flows in your organization. So do you almost have to go through sort of like source by source and going, candidates that we download from job boards, we need to do this. Candidates that we connect with on LinkedIn, we need to do this. So you're clear on what the basis for processing is, dependent upon where those candidates come from.
Yeah, and you know, I've put them together so that you should, for your sort of external facing business, rather than your internal use of employee data, for instance.
Okay.
If you're external facing business, you should only really need one privacy policy, unless you're doing different types of business within your group, in which case you may want to have more than one privacy policy. But for most recruiters, you should be able to put together a privacy policy that covers candidates, regardless of where you collect their data from, the client's contact data that you deal with, and anyone else's contact data, including contacts you may have at umbrella companies, and other third parties such as MSPs, for instance.
Okay.
That privacy policy should cover all of those, and you have different sections within it to describe where you get the data from and what you're going to do for it and what your lawful ground for processing is. That's the purpose of the policy. So it should tell a story and go through logically.
Okay, and if a candidate has sent you their CV, would you be able to imply consent when they've sent you that? Because they wouldn't send you a CV if they weren't hoping you were going to represent them and they are aware. So whilst you'd still send them a link to your privacy policy, if they've said, here's my CV, does that support the case that they've sort of consented to the fact that you're going to be representing them and using their data on their behalf?
Well, again, for GDPR, you're not looking for consent for that particular purpose.
Okay.
So if someone has applied through your website, let's just say, any automatic response they get or any response they get would still need to be directing that person to your privacy policy.
Right. Okay.
So you could say, well, they're asking me to represent them, so do we really need to do that? I would say, well, why wouldn't you do it? You might as well treat everybody the same. Why would you complicate the process? Okay. Just send it out to everybody.
What you're saying is your process is writing out, these are all the sources that we get people from. This is the privacy statement that everybody that we interact with gets a copy of.
Yeah.
That basically said, this is how we work, this is what we're going to do, and these are your rights.
Yeah. And then the crucial thing is, in doing that, you're not asking for their consent, because you don't need their consent. You're telling them what you're going to do. And provided everything you say in that policy is consistent with what you do as a recruitment business, i.e. you're not trying to do anything else with their data that the data subject wouldn't expect you to do.
Okay.
And generally speaking, that doesn't happen, but you have to be, you have to do an assessment to make sure you are doing things that would be within the reasonable expectation of the data subject.
So for instance, not selling their data to a PPI firm.
Exactly.
No.
Exactly. So you, as long as you've done that, you don't need to ask for their consent,
Okay.
except
And
for the very limited situations I mentioned. And the advantage of that is that once you've sent it out, you've sent it. You don't have to keep resending it, and you don't have to check that you've got their consent for GDPR purposes.
okay, so that sounds remarkably simple, if that makes sense. And I'm sure it's,
Yeah.
that's that's the simplest explanation I've heard. So a couple of scenarios I want to talk about. One is, what do I do with the candidates that are already on my database? I've heard of agencies deleting everybody.
Yeah.
Some are basically they're having a no upload CV policy, and this is sort of that's so commercially valuable for agencies. Making the wrong decision can have long-term implications. So what do you do with your existing people on the database?
Well, I think you ideally go through a process of working out, well, who do you need to retain, because it is important to minimise the data that you hold. So there inevitably will be records that are out of date and that you do need to delete. But anybody who falls within your retention decision criteria, so you'll have to decide on what those are, and that will vary from organisation to organisation. If you've made a decision to keep them, then you should be sending out communication to them saying this is our new privacy policy.
And that's all you've got to do is basically say, you're in our database.
Yep.
Here's our privacy policy. And you can fluff it up around the side, but as long as you're saying, here's our privacy policy, and if you don't like it, let us know and we'll take you off.
Yes.
You're good to go.
That's right. I mean, I spoke to somebody last week who they were about to launch a new website, and they said, "Oh, be a good opportunity to do this." And in one way, yes, but you've got to be careful that the message isn't diluted too much.
Okay.
The key thing is that you can show that you made it clear to them that you did direct them to the new privacy policy, and that information was there in a way that would give them all the information they need about the processing of their data. It doesn't matter that they're already on your system.
Okay, and so we'll get to some of the system solutions in a second. But the last one around consent is that obviously I get consent to process the data from a candidate, and then I'm going to forward that to a client. So do I need consent from a candidate to do that? Am I now no longer allowed to send a CV when I say it's a job in the southeast, it's management accounting, or do I just not even need to speak to them? What's the view on that?
As a matter of good recruitment practice and compliance and things like the conduct regs, you still need to get a candidate's consent to share their data with a client. And I think most recruiters do that as a matter of course anyway. That's not the same as getting their consent for GDPR purposes.
But am I able to get blanket consent to basically go,
You don't want to get blanket consent is the worst thing you can possibly do.
right?
Because to the extent that you are going to rely on consent, which I'm saying you shouldn't, but if you had to for health data, for instance, you'd want it to be specific to that health data.
But in terms of sending CVs for jobs, can I basically go, if something comes in and it's urgent, am I allowed to send you across? And if the candidate says yes, then I'm okay to send them to whichever jobs come in without speaking to them? Or do I need to speak to them about each individual job and then log going, spoken to about X, wanting to go forward?
Well, that's not really a GDPR issue. If provided you've put them on notice as to what you're going to do with their data,
okay,
it doesn't have to be refreshed with specifics each time you send their data on.
right, okay.
And it's up to to the extent that the client is processing a candidate's data, then the client has to put the candidate on notice of what it's going to do with its data. Now, how does that work in practice? Well, that varies massively, because at the moment, a lot of clients assume that recruiters are acting as their processors, which of course they're not for most of the recruitment process. So there's a bit of an issue there. But just because a client has not shared their fair processing information or their data privacy policy with a candidate does not place the recruiter in breach of the GDPR. So
Right.
that's the client's concern, not the recruiter's.
So when I upload a candidate to a client's portal, for instance, or a lot of recruit companies now are getting portals to sort of centralise all that CV knowledge and the candidate knowledge.
Yeah.
When a recruiter uploads them to that database, I'm okay because I've had permission to do that from the candidate based using my privacy policy. But then does the client need to communicate with that candidate to say, this is what we now hold your data as well, and this is what we're doing with it, and here's our privacy policy?
Well, you'd have to look at the specifics of how it worked as a process, but just some basic principles. Once that uploading happens, there should be some kind of notification on behalf of the client, if not from the client, telling them what's going to happen to that data next.
Right. Okay.
And who's holding that data. Because that, again, this gets a bit more complicated, Alex. So it's difficult to generalise about it. But as a recruiter, you do have to be aware of whether or not you are acting as a data controller or a data processor, and that the answer to that question will depend. As I say, a lot of clients assume, a lot of the banks I've seen so far have required recruiters to sign processor clauses saying that every bit of data they use in connection with the agreement is processed on behalf of the bank. Well, that's clearly not the case.
Okay. So I've got a question here. So we could easily end down a rabbit hole here. So I'm going to pull us out slightly for a second. And Rob Samuel has asked a question, and he said, how does this apply to client contacts in the system, e.g. client contacts on a database that you've held for a number of years, but you haven't spoken to for a while, but maybe you've had jobs with them in the past? Does the privacy policy apply to them as well, where you just email them and go, you're on the system, here's the privacy policy?
As long as you've drafted it in a way that covers your clients, yes.
And so if you're using, a lot of times client data is held for phone marketing and email marketing purposes. So is that not covered by different legislation than GDPR?
Well, the direct marketing legislation is different to GDPR and it's obviously very relevant. There's they work alongside each other. So I'm not going to get into that, particularly in this session. But to the extent that you are holding an individual's data on your system, GDPR is still relevant to you holding that data. And so, yes, you would still need to make a decision as to whether you still needed that contact or not. And if you decided you did, you would ideally notify them. Okay,
and that's got to be explicit, as in you can't hide that notification along with a mail shot or a newsletter. It's got to be, because
you could do, but you need to draw attention to it. It doesn't need to be freestanding, but you do need to make it clear in whatever you're sending that, in addition to all this other stuff, we are updating everything for GDPR purposes, and we want to draw your attention to our new privacy policy.
Okay, and so you could have that as an auto signature in your email. So when you're communicating with people day to day, it's consistently going, please check our privacy policy, which is sort of reaffirming the fact that you have one, and this is why and that will tell you why you're emailing them.
Yes, that's one way you could do it. It depends on how you're communicating with them. So you're allowed to do it electronically, so it doesn't really matter what your medium is.
Okay, great. Well, we could go all day on consent, but let's get to the let's go to the second one, which is, I can rely on LinkedIn or other job sites' data privacy policies to lawfully process candidates' data from a job site.
Yeah.
So why is that a misconception? Why is that a misconception, Francis?
Well, I've heard quite a number of people say in deciding to upload their information to a job board, a candidate has basically given their consent to anybody using that data for the purposes of providing recruitment services, and that's not the case. So again, going back to what we've just been speaking about, anybody who you find on a job board or on LinkedIn who looks like they could be useful for a particular position, or just generally speaking for market research purposes, it doesn't matter the purpose for which you're collecting their data, you do still need to put them on notice of the fair processing.
Right, okay. And so, because I guess LinkedIn will have a privacy policy that covers what they need it for, not necessarily what the recruiter needs it for.
That's right. So it doesn't extend to anybody else.
Okay. So
there are a few very specific exceptions that you know, if you actually had to, you might be able to rely on. And again, I'm not going to go into detail about that, but generally speaking, we recommend that you're not relying on exceptions because they should be a sort of last resort, if anything. Okay.
Great. Well, I've got a couple of. I just want to go through some of the questions. So, I heard somewhere recently that if you use consent and don't attain it, you cannot then fall back on LinkedIn to say they consented. Is that right?
But you can't do that. I mean, that's the worst. That's one of the main reasons for not seeking consent unless you have to as a legal requirement. Right. Because if someone doesn't give it, you can't then go back and say, well, actually, we've decided that our lawful ground is legitimate interest instead, because they've either explicitly or implicitly denied their consent. So you can create a massive problem for yourself by asking for consent and then not getting it.
Right. So that, for instance, the example I gave early in the set call, which was sort of someone emailed their database and went, we need to get your permission, please click this button so we can communicate with you. In effect, they now can't do anything because if you haven't replied, you've opted out. So basically, they unless someone clicked a button, they now can't email that person within the approach that they've taken. Is that right?
Again, this is more relevant to direct marketing, but it's essentially the same point, which is that if you are asking somebody to respond to a notice you've sent out or a request that you've sent out, if they don't respond, you can't assume that was sort of tacit consent. It's the opposite.
Right. So where in the past you could sort of automatically assume if they didn't opt out, they'd opted in. Now, if they don't, they've got to consciously opt in. Okay. So I've got one other question, which is, you're going to have to bear with me because I'm reading it from the notes, but it's a statement, and more of a statement from Alan. He says, you should be unbundling your processing purposes from your privacy policy and inform the individual with processing information relevant to the reason you are collecting their data. The transparency guidelines from WP29 recommend that having all your processing information for the various purposes you process bundled into your privacy policy. It recommends not doing that. It should be delivered in context to the individual. They shouldn't have to scroll through a bunch of non-related information in your privacy policy to understand how you intend to use their information.
Yeah, I mean that's obviously that's not wrong. It's just that in terms of the processing that a recruiter will do, it's actually relatively straightforward. So you're not providing them with reams of irrelevant information. In most cases, the processing will be the same for every single candidate. The processing for a client contact is going to be relevant to the processing you're doing for the candidates anyway. So as a sort of business process, it fits together quite easily in terms of having all that information in one policy. As I say, if you've got different activities going on within the business, then you probably will want different policies for those activities. So again, a couple of weeks I was speaking to somebody who's got, as part of their CSR, they've got an arrangement with local schools and getting candidates from certain backgrounds into clients on a CSR basis. That would have to be subject to a different privacy policy because it's an entirely different use of the data, and you've got all sorts of complications around people under age 16. So anything that is slightly different to your sort of mainstream recruitment process, then you'd have to sort of factor that and consider it. But for most purposes, the actual recruitment process is actually quite straightforward and lends itself well to
With what Alan said, then I guess the key is to have a privacy policy that's really discreet and clearly laid out, where they can get what they need quickly and easily, rather than it being like Apple or Google's terms of business, for instance.
I mean, they're not a page long. You know, they're sort of. I was looking at one this morning for about 4 pages long, but you can link information. The key is to make it accessible and easy to understand.
Great. Okay.
And you know, if anyone does read it, as long as in reading it it makes sense to them, that's the important thing. Which is you can do that with candidates.
Great. Okay. And so on to the next misconception is that the CRM can deliver full GDPR compliance. I hear this all the time, and I guess it's the systems providers that are sort of purporting to have the most silver bullets. So why is that a misconception, and what are the risks that businesses expose themselves to if they rely too heavily on those CRM solutions?
Well, it's not that a CRM is not going to be a very helpful tool in delivering GDPR compliance, because clearly it is. I suppose the challenge is getting all of the candidate and client data onto the CRM at the earliest possible stage, because until it's on there, it's not part of that compliance and security process. So, you know, it's not unusual for recruit consultants to have their own sort of localized Excel spreadsheets of contacts. You know, used to be called sort of top pocket databases, whatever you want to call them. They're not on the CRM. So this also relates to the last point you were going to raise, Alex, which is that what we are seeing is that senior management are looking at it as a way of forcing the use of the CRM at the earliest possible stage, because it's only at that point that the business is able to manage and take control of the data. Until it's on that system, they're not controlling it at all, and it is a bit of an Achilles heel for the organisation.
Well, I guess what the CRM can do is help automate some of that communication, which is basically saying, here's our privacy policy, nice to meet you, and giving candidates that ability, a bit more control on what happens with their information and what.
And again, going back to the importance of having the right privacy policy, I mean, that it's important that, if at all possible, that is done by the organisation, or at least the information that needs to be mentioned in it is done as a result of a sort of data processing mapping exercise that the organisation has been through, because otherwise you end up with a sort of vanilla policy that doesn't give you the protection that you need. So you'd need to work with whoever is providing these solutions to make sure the content is right for your business.
Right. Okay. And so we've got a bit of chat going on around Excel. So how are businesses managing Excel risk within the GDPR projects that they've got going on?
Well, I can only speak from the meetings I've had. I think that a great number of recruitment businesses have been looking for a way to sort of stamp out those individual practices, and so they're using GDPR as a way of forcing the consultants to not use Excel spreadsheets. Now, I appreciate that, you know, some businesses are heavily reliant on this, some aren't, but it does create a bit of an issue in terms of making sure that the information is secure, that the information notices we've just mentioned have been sent out at the right stage, because otherwise you just have a whole load of data held on a spreadsheet that nobody is policing or controlling. The data subjects held in that spreadsheet have not been informed that they're there, or the processing that the organisation is planning to do with their data. So it is quite a significant risk to do that.
I know from in Nurture It, we've had a few clients, because a lot of CRMs don't manage leads very well, and we're mainly focused on lead and pipeline management. We've had a few companies that have come to us as a solution to remove those needs for spreadsheets, but as a halfway house between putting everything on the CRM. So
Yeah.
So that people are definitely looking to try and stamp out the spreadsheet side of things. And what about paper? Recruiters love printing out a CV. And if you go into any recruitment office, you're going to have hundreds of CVs floating about. What's the solution, or what are some of the things that businesses need to consider through that process?
Well, again, I think it's a move towards a paperless system.
Right. Okay.
Yeah, that's the ideal, and this is a good reason to do that.
Right. Okay.
It's not trying to sort of suggest that people don't use it and they don't need to use it, but it does need to be reviewed and then assesses whether, is this a risk that we're prepared to take? And if it is, how can we put some kind of control management around that so that it reduces the risk as much as possible?
Right. Okay. And so I guess, so there's a risk mitigation. If you've got a confidential recycling bin for shredding, you can still print off CVs as long as none of them are left on your desk at the end of the day. Is that an example of a?
I think that's our system. I mean, we've got the same here. We have a paperless system now, apparently.
And that's the challenge, isn't it? So,
but every year we get closer to it, and this time next year, I think most people will be almost completely paperless.
Right. Okay.
So, and if it's not being deleted, it needs to be locked away somewhere secure. All of those sort of common sense measures should be in place at least as a matter of policy, if not practice.
Okay, and just a quick one. A few people have asked about LinkedIn in-mails.
Right.
So obviously within LinkedIn, within your recruiter license, you can email people directly. I'm assuming because you're using in-mails within LinkedIn, effectively they've already obtained consent or business interest for them to receive that email because LinkedIn is a part of the LinkedIn's business model.
But I think, again, it just goes back to you're not trying to obtain anything. This is about notification.
Okay.
So change the sort of mindset around what it is you have to sort of lay the ground in order to use that information. The answer becomes a little bit clearer. So you're not trying to obtain anything from the candidate. You're trying to let them know what you're going to do with their data, and that's a completely different way of approaching it.
And so I guess within LinkedIn, until they respond to the LinkedIn in-mail, you don't have their data. You've just got the ability to communicate with them. You don't have email addresses.
You'll have to forgive me because I don't know exactly how that works, but if the information is held on your system, then you do have to do something with it. If it's on LinkedIn's system, then you're not holding that data.
Right. Okay. I guess that clarifies it. So if it's an in-mail and you're using the LinkedIn recruiter license, that's all held in LinkedIn's system. So therefore, that's covered by LinkedIn's own privacy policy. As soon as I then take that information and put it on my system, then I have to inform them of my privacy policy.
Yes, but in contacting the candidate, whether that be via email or whatever the method is, you should still be notifying them of that processing.
Okay. Right. Okay. That's
I don't know how easy it is to attach things to the email. That's why I'm hesitating, because I've not used that in practice. I'm aware of it, but I haven't seen it happen in practice. Okay. So I'd have to look at that.
Cool. Well, we'll maybe do a post-webinar Q&A on a written one on LinkedIn in-mails, because I think that's a primary way that a lot of recruiters contact candidates initially is in LinkedIn email system.
The crucial thing is to just make sure that that's got some kind of reference or link to the policy.
Okay. And then put that as a signature in that LinkedIn email, which is basically going, by the way, I'm Alex and here's my privacy policy.
Yes. Okay,
great, cool. So we're into the last. We've done 3 misconceptions. We're into the last half of misconception. So is my recruiters won't have to change the way they work, because once I've got my policies in place, once I've got my system in place, life goes on as normal.
Well, I think that ideally they will need to change the way they work. As we said, they've got to start engaging with the CRM at a much earlier stage, and I think that's common to most recruiters that I've spoken to. They probably do need to have some training on GDPR and the way that they use data could actually either help the organisation or create some kind of risk situation. So they will need to have some kind of training on that.
Right. And what does personal behaviour and conduct appear in the GDPR regulations? Is it just about process, or does actually the culture of valuing personal data, does that appear anywhere in GDPR?
Well, the GDPR is meant to be a change that actually promotes the value of data to organisation, and the need to have data subjects and the value of their data at the centre of decision making within the organisation. So there is a cultural change there that the law enforcers are looking for. It's not just a tick box exercise as it has been in the past, and that's the main reason it's been updated. I mean, obviously the use of data has massively ballooned since the Data Protection Act came in a few years ago, but it's also because they want data protection to be taken seriously and to become crucial to strategic thinking within the company. So in terms of what recruiters do to use the data, they are going to have to appreciate that, and that's where the training would come in. It is a change in mindset as well as process, and making sure that you've got notices going out at the right time to the right people.
And what are some of the sort of poor practices that you've seen in your experience that recruiters do that they need to stop doing in terms of culturally within an organisation that will expose them to higher levels of risk?
Well, as I've already outlined, I think the storing of candidate data outside the CRM is a big issue. There are lots of services that are based outside the EU that do things like format CVs, for instance, for a fraction of the cost it would be in the UK. But sending candidate data out to those organisations where there's no contract, there's been no kind of check on the security within those organisations, no check on whether or not those organisations are then forwarding them to third parties. I mean, things like that are going to have to change, because you can have the most wonderful CRM in the world with all of its bells and whistles, and you've still got a problem with a whole load of data that's been sent out of the country and not managed properly. So there are lots of examples like that I think we are going to see changing, certainly over the next sort of year to 18 months. It'd be interesting to see what does happen in terms of enforcement in that time, because that will largely set the tone of how far people want to go with this. Okay,
great. Well, that's some terrific answers there, Francis. We're getting towards the end of the webinar now, but Greg's just popped up with something, and he said, "You say that we're not looking to gain anything. Surely just notifying the candidate of a privacy policy isn't getting demonstrable, explicit consent for communication, which is what I believe is needed."
No, you're not. Well, by all means go for consent, but we don't advise it.
Okay. And I guess for that, see a bit more of the beginning, because I guess, so what you're saying is that if you say this is what we're doing and this is why we're doing it, then you're falling back on legitimate or business interest, which is easier to stand by than getting explicit consent for communication.
Yes, and I think that's where the biggest misconception is, that no one's saying that you shouldn't rely on consent as a ground for processing. But if you do, you have to understand what that means. And in many cases, what you end up is with no lawful ground for processing the data, which means you can't process the data at all.
Right. Okay. And so someone's basically said, so we're going into the quick fire questions now. They're all coming in. So
Can't read them.
can we spec out a CV to a client, even though the client hasn't agreed to our terms of business?
Well, that's a different question. It's not necessarily to do with GDPR.
Right. Okay. What is it to do with?
Well, if you're making a speculative approach to a client, you mean?
Yeah.
Well, as long as you have, you're basically talking about direct marketing there. So that's
Okay.
a whole different subject that we just haven't got.
When changes to e-privacy coming in? Is that the end of the year?
Pardon?
Is the changes to e-privacy legislation coming in at the end of the year?
I don't know if we've got a specific date yet, but they're certainly underway at the moment. So, yeah.
So Francis, do you want to tell everyone how they can get hold of you? If they like what you're talking about, or has any other questions that eventually they might have to pay for? How do people get hold of you?
Well, I'm at Osborne Clark, so I'm francis.lewis@osborneclark.com.
Great.
And I'm sorry I've not been able to read all of your questions. There's a lot of them there.
Yes, no, and we've had some great chat. There's some other individuals on here which have been sharing insights. So, but for the second time, I just want to say thank you very much for coming in. We're not going to have time to look at some of the IT security and technical requirements that people have been asking for. Please remember, for the replay, check out nurturit.io. We're the place that helps you manage your pipeline more productively. Francis Lewis, you've been a superstar. Thank you very much. And hopefully we might even have like stage 3 when we go live. So hope everyone has enjoyed it, that's watching, and we will see you all soon.